Thank you. Please be seated. Last case on this morning's docket is State of Texas versus Harris County. Mr. Mendelson.
Mr. Chief Justice, and may it please the Court. The Texas Supreme Court has already held that the original Uplift Harris program is very likely unconstitutional because it lacked constitutionally sufficient controls as the gift clauses require. Their new argument and their new program is no better for largely the same reasons that our Supreme Court already articulated. Perhaps realizing that problem, the county has attempted to insulate its new program from judicial review by contending that the Attorney General has no common law rights, an argument it failed to make in the Uplift Harris case just a few months prior. I'd like to begin there and then address why the county's new program still violates the gift clauses. Harris County's argument proceeds from the wrong premise. The Constitution and all statutes of this state are written against the background of the common law. Section 5.001A of the Civil Practice and Remedies Code adopts the common law by statute. And in modern Texas Supreme Court cases like Taylor v. Tolbert, the Texas Supreme Court has explained that we need a clear statement rule from the legislature or the Constitution to repeal the common law. And we know that that hasn't happened here from several cases, the most important of which is the Hollins case from 2020. That was the case in which the Texas Supreme Court, in a case procedurally identical to this one, held that the state had the intrinsic right to enforce its own laws. And when I say procedurally identical, what I mean was that the state, acting through the Attorney General, brought a common law ultra-virus suit against Harris County officials for violations of certain provisions of the Election Code, procedurally the same as this case. And in that case, the court held, we reiterated that as a sovereign entity, the state has an intrinsic right to enforce its own laws, and where those laws are being defied or misapplied by a local official, the ultra-virus suit is a tool to reassert the control of the state. Hollins also drew on some very important prior Texas Supreme Court cases like Yett v. Cook in discussing these common law powers. Yett v. Cook explained that under the ancient and modern rules of the common law, this is page 221 of Yett v. Cook, the state has a sufficient interest to and can maintain an action, in that case, against municipal officers to call an election. It then said, since the state can bring a proceeding in equity, it was talking about a mandamus suit in that case, similar to the one before the court there, it's elementary that the Attorney General has the power to institute such an action. That is essentially the basis of this suit. And there's also another important case in the same vein that shows that the common law hasn't been repealed. And that's a case from 1893 called Queens Insurance Company versus the state.
Is there anything in the, again, I'm nervous about being the brand new court doing something brand new. I understand 19th century cases are not brand new, but it's been a long time. Anything about common law right to just file suits that in more recent years?
I think Hollins is the perfect example of that. Hollins was a case from 2020, and of course, since Hollins, certainly the Texas Attorney General's office has used the ultra-virus cause of action many times against various local government entities. So this is a relatively common procedure, certainly since Hollins.
And so, similar to our earlier case today, is the basis for jurisdiction against the county, is the Uniform Declaratory Judgments Act basis against the county officials, is ultra-virus?
So the basis against the county officials is the ultra-virus cause of action. The basis against the county entities is City of Elsa and City of Beaumont v. Bullion, which is the implied right of action in equity, of course, not for damages, for constitutional violation. So that one is the proceeding against the entity, but of course, what I was also referencing was the ultra-virus cause of action.
Got it.
So that is the basis for how the Attorney General can bring the suit in the first place. And I suspect that my friend on the other side might bring up some cases like Harney and Garcia, but those are cases that are about statutory causes of action. They're not about common law rights of action. And that's also a very important distinction because I suspect my friend on the other side is going to bring up a case called Paxton versus Longoria. And I want to be extremely clear, the Attorney General's office has not contradicted the litigation position that it took in Paxton
We
versus
got that, we
Longoria.
got that in your brief.
Right, that was a statutorily created cause of action for civil penalties, and I just want to be clear that on pages 42 and 43 of that brief, argument heading 3C, we said we could use the ultra-virus cause of action, and we specifically discussed the
And
Hollins
so
case.
the appeal here is on the temporary injunction. We've had a final judgment entered. Straighten me out on how, what issues the final judgment merges into issues that were briefed on the temporary injunction.
Sure, so several issues. One, of course, is they brought up the issue I was just discussing. One, of course, is the gift clauses, the actual merits of the case. And I do want to be sure to turn to that now. And
Well, before you do, just to follow up on the chief's question, and I just may be missing something, but if a court decides it has no jurisdiction over an action, how does it then amend its judgment to say, oh, and in addition, I'm going to grant the motion to show authority, even though I don't have jurisdiction to do that?
I think that's a fair point to make. My friend on the other side relied, I believe, on the plenary power of the court within 30 days. We're not here to dispute that, only to note that the judgment, of course, has been superseded under a 27-3 notice. So to the extent my friend on the other side argues that the pleadings have been struck, well, that's not actually true. That entire judgment was superseded by the state supersedious. I'm not sure if that was the court's question.
No, it is, because I'm just trying to, just as a threshold matter, if a court decides it has no jurisdiction, how does it grant any motion?
Right, I certainly think that's a fair point, and that the motion to strike was filed after final judgment had been entered. That's certainly correct. With that said, we think that regardless of the remedy, we still, for the reasons I just articulated, have the right to bring the suit.
Could you address the city of Elsa point and why Heinrich doesn't eliminate that as an argument?
Well, Patel, of course, reaffirmed the city of Elsa and the city of Beaumont v. Bullion case. Heinrich, of course, was about Heinrich was about a private individual, and I think that was an ultra-virus cause of action in Heinrich. With that said, Patel expressly reaffirmed the city of Elsa. Patel was 2015. I think Heinrich is 2009. And it explained that although, of course, there's no such thing as an implied right of action for damages, Texas has no Bivens, Texas has no 42 U.S.C. 1983, you can bring an implied right of action on the basis of the Constitution itself for only, of course, equitable relief. But I also don't think the court really has to address that issue because, of course, the city officials are also proper defendants, most importantly, the executive director of the Harris County Public Health Authority. I do want to be sure to address the gift clauses point, the merits of the case, and we think that for largely the same reasons that the Texas Supreme Court articulated in In Re State, also known as the first Uplift Harris litigation, that there's still no sufficient controls. And what Uplift Harris held was there will be no public control over the funds after they are dispersed. And that's why half of the 6 controls that my friend on the other side discusses in his brief aren't relevant here at all. Controls like giving money to the third-party administrator in increments or determining eligibility criteria for who might receive the funds in the first place are wholly irrelevant.
Why doesn't the capacity to audit and potentially kick someone out of the program count?
Well, I think there's several important reasons for that, and that is that there are no audit procedures in place. There is no audit. The word audit is just a word in a contract, and I want to be sure to emphasize why that is. This is a 2 Reporters Record 67, and this was the trial court speaking to Mr. Maddox, who was Harris County Public Health's witness, and the trial court asked him, so let's say somebody goes to a car repair shop and spends the $500. You don't intend to restrict how somebody how a program participant spends the money. And he said, that's right. And the trial court said, meaning the allotment for the month. And he said, that's right. And then, and this is a 2 Reporters Record 82, Mr. Maddox was asked, well, how are you going to know if you need to kick somebody out of the program? Let's say they're using approved merchant category codes. He says, I think there's more planning to do in terms of identifying the specific mechanisms in which somebody is removed from the program. This is a 2 Reporters Record 83. Mr. Maddox was asked, well, let's say a transaction occurred at an approved vendor. how would the county remove someone from the program? He says, I don't have a specific example. We don't yet know what we don't yet know. I want to emphasize for the court, his testimony was, we don't yet know what we don't yet know. The word audit is a word in a contract. There's nothing behind the word audit.
Would there be any provision, say it's the last payment and someone decides to, buy lottery tickets with it or something, like at the point that it's the very last payment, is there a what happens if the program's over and you can't kick someone out of it anymore?
If I understand the court's question to be asking, is the control only for the last payment, or is the control?
Or, no, I'm just curious, is there anything in the record saying, there's this provision, and let's say it is a control that you could kick someone out of the program, but say it's the last payment and the program is ending, they're going to be out of the program either way. At that point, is there anything in the record that there's some control beyond potentially being kicked out of something that's already over for that last payment?
I don't think so, and I think that's certainly an important point for the state, because it seems that what they're saying is, well, we could kick somebody out of the program, but they don't have any procedure in place for how they think they're going to do that. And they also, maybe this also goes to the court's question, is there's been a lot of discussion about the contract, the attestation form, and that says, well, we'll make somebody sign a contract that says I consent to providing necessary documentation if requested. And then, this is a 2 Reporters Record 93, Maddox was asked, well, what documents would you require? And I think this goes to the court's question of what, maybe if the program is over, what happens? And Maddox says he didn't know. He says not at the moment, but that they were still working on that. So it appears that there's really not any procedures in place for how this actual program, how this audit process would work. I also want to be sure to point a little bit out about one of the changes that they've made since Uplift Harris, and that is the use of merchant category codes. What I'm referencing is 6 Reporters Record pages 11 through 13. And Harris County has taken the position that, well, our debit card that we're going to give the program recipients is only going to work at places with approved merchant category codes. Those are written at such a high level of generality that they have almost no value at all. They say discount store, variety store, drugstore, pharmacy, gas station. And they're saying, well, in their contract, they say the program is restricted to the merchant category codes. That's Walmart, that's CVS, that's Walgreens, that's any gas station.
Isn't that some degree of control, though? I mean, it doesn't have to be a perfectly regulated system, right, in order to pass muster, or does it?
Sure, but under these facts, I don't understand my friend on the other side to be arguing that all of the products that one can purchase at any of those places would fulfill their public purpose. And what the Texas Supreme Court held in Ray State was 2 important things. Controls have to be enforceable, and they have to be good enough to where we can see if they're fulfilling their public purpose. I don't think Harris County believes that their public purpose is any product that can be purchased at those stores. That would include alcohol, cigarettes, chewing tobacco, lottery tickets, and I don't understand them to be arguing that that is fulfilling a public purpose of poverty relief. And as long as we're on the point about the merchant category codes, I want to dispel the myth that this is not like the TANF program. This is not like the SNAP program, and they say that they've modeled it after those things. That's not true. Those programs are administered via something called the Lone Star Card that's issued by HHSC. The court might have seen signs at places like HEB that says Lone Star Card accepted there. As Maddox explained in his testimony at the trial court, those are programs in which vendors like HEB opt into them, and they have a list of approved items, what are called SKU numbers, stock keeping unit numbers, to where the Lone Star Card won't work at the register if somebody isn't using a list of approved items. So that's the difference between how that program works and how the use of merchant category codes in this program.
But there's nothing in the Constitution that says you specifically have to have that set up, right, in order for your program to
No, there's nothing that says you must always do it the way the state does it,
Right.
but you have to, the point I want to make is that this is not the TANF or the SNAP program. I think the answer to the court's question is you have to know if the controls are enforceable. The Texas Supreme Court says they have to be enforceable, and they have to be enough to where you can actually see if you're achieving your public purpose. And we don't think that these controls here are enforceable because they don't seem to have any teeth behind them, or if they're actually achieving their public purpose. And I see I'm almost out of time, so the last point that I want to be sure to make is that this case is pending before this court right now, and there's also a case called the original Uplift Harris case. And Harris County has an obligation for as long as they submit to this court's jurisdiction to confirm the presence of jurisdiction. They repeatedly told the Texas Supreme Court and this court that they had to commit these funds by December 31st, 2024, quote, or lose them forever. That was what they told the Texas Supreme Court, and I'm hoping that we can get some clarity as to which program they've committed those funds to. Thank you.
Thank you, Mr. Mendelson. Mr. Martinez. Can you answer the last question first? Are the funds gone, or are they still there?
Your Honor, they're still there. After we've made those assertions, we've done further analysis and identified a separate set of funds that are not subject to those same restrictions. So we are still interested in pursuing either the Uplift Harris program or the Community Prosperity program, which it's going to come down to sort of what courts rule.
And is there any other deadline now that we know that December 31st, 2024 doesn't apply?
There's none from federal law. The Commissioner's Court is eager to put
Sure.
this money to good use, and so if we don't get a decision sometime soon, then we'll you know, they'll be considering whether to move on.
We'll do our best.
Thank you, Your Honor. Can I just say that the simplest, cleanest, and quickest way to resolve this appeal is to affirm on the basis of the Attorney General's lack of authority to represent the state in the district court in this case. That conclusion is supported by the text of the Constitution, numerous Supreme Court decisions, the Attorney General's own briefing in the Longoria case, and even the evolution of the constitutional text and the ethos that was driving the 1876 Constitution. So I'll start, as I think I should, with the text. The text of the Constitution says the county attorneys shall represent the state in all cases in the district and inferior courts in their respective counties. So that's my bedrock. And the question is, you know, what are the exceptions to that rule?
Well, I want to push back just a little bit. So is it your position that the Attorney General has no powers at common law that are relevant here? We're only limited to that statute itself?
It's that the Attorney Generals can only exercise powers prescribed by the Constitution and statutes. He does not have any common law authority beyond that, and case after case after case from the Supreme Court has said that.
So, but in Yet, which Hollins relied on pretty heavily for its judicial dicta, which we have to follow. We don't write on a blank slate here. We have to follow that if it's not clearly erroneous. And Yet cited a host of cases recognizing pretty broad powers of the Attorney General at common law that have even been recognized for state attorney generals at the U.S. Supreme Court. There's a Fifth Circuit decision, I think from 1976, talking about you know, these broad baseline powers, and that, you know, states typically, if they're going to take away those powers, they're going to do it expressly. So do we just chuck all that, or are we not in common law era anymore? Because we do have Civil Practice and Remedies Code 5.001, which makes common law law. So what do we do with that?
Sure. Well, let's talk about that statute.
Okay.
That statute says it's not just adopting the common law for all purposes of how we run our government. The statute is specific. It says the rule of decision in this state consists of those portions of the common law of England that are not.
That doesn't conflict, right?
What's that?
That's not in conflict.
Right, and I view the statute as addressing the rules of decision for how courts decide cases, right? If there's two stacks of hay next to each other and, you know, a guy subjectively doesn't think they're going to catch on fire, like, is that negligence, right? That's different from what powers and duties government officials have, right? We have a written constitution that specifies those powers in significant detail, and the Supreme Court has repeatedly said that the Attorney General does not have power beyond the Constitution and the statutes. On the yet point, first of all, the state didn't really press yet as a basis for its common law authority in its opening brief, and so we didn't really respond to that.
But we can't ignore, like, a Texas Supreme Court case that's been on the books for 100 years, right? Nearly.
Well, so I would say that after yet was decided, the key cases are Harney and Garcia, right? In Harney, the Court of Appeals rejected the notion of implied or common law powers of the Attorney General. The quote is, "As the powers and duties of the Attorney General are prescribed by the Constitution and statutes, those powers must be limited to those so prescribed and may not be enlarged by the courts." Okay? So that's what the Court of Appeals said, and then Garcia is a Supreme Court case from 1955 that says, that expressly approved Harney. It said Harney was correctly decided. We didn't take the case, but if it had been incorrect, we would have taken the case.
But is that a case where there was a suit to try to compel local officials to comply with state law, or?
It was a suit in both Harney and Garcia to remove county officials pursuant to provisions of the Constitution. Harney held that because there was no statute or constitutional provision authorizing the Attorney General to bring suit on behalf of the state in the trial court, the Attorney General lacked that authority.
So what do we do with Hollins then?
Hollins is a nullity here, right? The Attorney General's opening brief recognized that this issue was not raised in the Hollins case. It was not raised, it was not discussed, it was not considered, and it certainly was not adjudicated, right? The words Attorney General do not appear anywhere in the Hollins case. So it was not adjudicating the Attorney General's authority to represent the state. The Hollins case was addressing the state's, whether or not the state has an ultra vires claim against local officials, and whether or not an ultra vires act is automatically sort of irreparable harm to the state. It was not addressing who gets to represent the state.
But the Attorney General was the attorney in that suit, right?
Yes,
Right. Okay.
right, but the issue, this issue of who gets to represent the state was just not addressed. I looked at the briefing yesterday. Oh, sorry, Mr. Chief Justice.
No, but the UDJA impliedly is a statute that creates a cause of action where you have to join the Attorney General to address the validity of a statute or ordinance. We're addressing an ordinance, and whether the ordinance adopted by Harris County Commissioner Court is valid, and so the Attorney General's got to be a party because the CPRC says so, right?
Well, Your Honor, they have never pressed that argument. In the trial court where they had the burden to show their authority, they said, we have no statute. Okay, so set aside that they didn't meet their burden.
They can't waive that. They can't, the waiver of immunity is up to the legislature. They may say that when they get sued and appear, and don't want to appear, but, I just don't see how that's, it's an odd thing, but it's, I guess, one could argue, well, there's a difference between immunity and motion to show authority. But, and of course, this is what this court was created to do, issues where the validity of a statute or ordinance, and our jurisdictional statute says, and the Attorney General is a party. Now, it is an odd thing that the Attorney General, in many circumstances, as in Ray Schmidt's about, class actions, where the Attorney General files a class action against an insurance company, and they are both attorney and party. And it's apparent they can do that. Nothing in the legislature says they can't do it. So I'm not sure the distinction between a party and being an attorney for a party, if what we're talking about is the validity of a statute, who else can we get? I mean, the county attorney's not going to sue the county commissioners a taxpayer's not going to be allowed to because they're not going to have taxpayer standing. if anybody is going to challenge this under the state constitution, it has to be the Attorney General. That's why we imply that waiver in the Civil Practice and Remedies Code.
So that was a lot.
That's
If
a
I could-
mouthful,
Yeah, so
I know.
So just sticking with the UDGA point that you originally brought up, it's because they didn't press this, I haven't reviewed it recently, but my recollection is that it applies to municipal ordinances. And of course, the county is not a municipality. So I query,
Yeah,
does
take-
that even apply to a county?
I'm not trying to trick you. And,
No, I know.
you know, these are big questions, and we're being asked to decide them all for the first time. So things occur to us that may not occur to you. Please feel free to give us a letter brief, not a big, long brief, but a letter brief saying this is the answer to that.
Sure, and whether or not, I don't know that the UDJA says that the Attorney General, when so joined, represents the state. And I think that's really the critical question.
It says they've got a right to be heard, must be served with a copy of the proceeding, and is entitled to be heard. And says, well, so that doesn't make them a party. It certainly, you know, I mean, why are they entitled to be heard? They have a justiciable interest. And the courts use that as a basis for saying sometimes yes, sometimes no, that, you know, what is the doctrine of virtual representation is going to apply because they've got a right to be heard and all, you know, I mean, this is a complicated area that we got to sort through a bunch of different cases that, as you say, haven't exactly answered our question.
Well, I think that that the Harney and Garcia case have come as close as possible to answering your question.
But back, so again, my concern is the railroad question.
Yeah,
You know, a county commissioner's court and the county attorney wants to please them. And so the county commissioner's court do something, forget about our case, do something that is clearly barred by state law. This, you can't do it. Doesn't have to be the Texas Constitution, the general law. And the county attorney is not going to challenge that. District attorney does criminal cases, they're not going to challenge it. No taxpayer can challenge it. Is this just a oversight in the Texas Constitution? I'll agree with you, the Constitution says, you know, Attorney General appears in Court of Appeals by statute and the Supreme Court, as a matter of Constitution. It doesn't say anything about district courts. And unless we have a statute like the UDJA or something else like that, they can't just show up in district court. So do we write an opinion throwing up our hands and saying, this is just awful, but counties can do whatever they want?
I do think that the Attorney General's limited authority in the district courts is a feature and not a bug. Going from the 1869 Constitution to the 1876 Constitution, the people of Texas deliberately reduced the Attorney General's control over things that are happening in the trial courts.
They didn't like those people in Austin, I got that.
Yeah.
Still don't to some degree, but that's a
Sure.
different question.
Well, and I don't know that I agree that there's no one who could do this. The legislature could pass a statute that allows the Attorney General to come into court and represent the state. The rest of the provision on the county attorneys says that the legislature can regulate the duties between the county attorney and the district attorney. So the legislature could also pass a statute that says if the county attorney is conflicted or unwilling to represent the state, the district attorney could come in and do it. And there are going to be some instances in which a party affected by county action will have standing to challenge that with an ultra vires suit. So it's not that there's no remedy. And really, ultimately, the people are sovereign, right? If county officials are regularly violating the law, the people can vote them out. This is pretty similar to the Harney and Garcia cases, where the question was who gets to represent the state, or not really who gets to, but does the Attorney General get to represent the state in district court for the removal of county officials? And the Harney case said, no, there's no statute, there's no constitutional provision that allows him to do it, so he does not have that authority because it's not in a statute and it's not in the Constitution. And it's the county attorney's responsibility to do that. And you might have the exact same, question, like, well, when is the county attorney going to want to remove from office county officials? I mean, Ms. Garcia was a county commissioner, right? This idea of common law powers, I want to get back to that, and Yet versus Cook. So I think Harney and Garcia are later cases that reject that. They say that it's limited to the Constitution and to statutes, and it can't be enlarged by courts by recognizing some vague, inherent common law power. The Hill case is great for me. It's Hill versus Lower Colorado River Authority. And in that case, they were addressing this issue of the Attorney General's common law power. And in 1978, here's the quote from that case. The Attorney General concedes that the recognition of common law authority believed to be found in the cases just reviewed, which included Yet, is interrupted by 3 cases. And it's Garcia, Harney, and a third case from El Paso. And the Hill case looks at all of that and concludes that the Attorney General only derives power from the Constitution and from statutes. And then that principle has been reiterated again and again and again. In Perry versus Del Rio, the Supreme Court said the Attorney General can only act within the limits of the Texas Constitution and statutes, and courts cannot enlarge the Attorney General's powers. What did Perry Del Rio versus Del Rio cite for that? It cited Harney and Garcia. Chief Justice Brister in City of Galveston said the same exact thing, and he cited Perry versus Del Rio, and he cited the Day Land and Cattle case from 1887, which is exactly what I'm saying here. We have a written constitution that specifies the powers of government officials in great detail, and government officials should not exercise power that is not mentioned in positive law, right, in the Constitution and statutes.
So you would have us write an opinion saying there are no more Attorney General common law powers under Texas, in Texas, right? That's what our opinion would need to say.
Right, that unless there is a statute that authorizes the Attorney General to represent the state in the district court on ultra vires claims, he does not have that power. Now, there's a limited category of cases dealing with private charters of private corporations, as you guys just heard, as the court just heard.
Could we also get to the control point before you finish your time?
Yes,
Yeah.
Thank you, Justice Ferris. So we've got 6 controls, and we discussed a variety of them, but the new controls that we have bring us a lot closer to Borgelt. In Borgelt, the Supreme Court addressed presumption after presumption after presumption that go in favor of the locality trying to do these programs. And one of them is a presumption that the parties to a contract will adhere to the terms of their contract. And our contract says that these funds will only be used for basic goods. Then we have audit rights. And my friend on the other side said, well, these are toothless and they're not fully developed. And that's because they sued on a facial challenge before we were done developing the program, right? So they're essentially bringing a facial challenge to this program and have to show that in no instance could we develop the audit rights in such a way that they would have the effect that's intended to make sure that the funds are being used for their purpose. We can ask for additional documentation, receipts to make sure that people are complying. Justice Ferris, I think you asked about, after the last one goes out. I mean, there are common law causes of action for breach of contract, right? So there are remedies to people not complying with the contract. But Borgelt says that people not complying with the contract is not a manifestation of the program. It's a breach, and not every breach of a contract is going to give rise to a constitutional violation. And essentially it says that if that were so, courts would become the full-time hall monitors of local government action. So, I mean, it's the state's burden to show that, this set of controls collectively is not going to be sufficient. I'm happy to talk about any other aspects of the test, but we do receive return consideration in the form of information, and we do have clear public purposes. There's unrebutted testimony that shows what the public purposes were. I guess I would just conclude by saying that the text and numerous Supreme Court authorities support the conclusion that the Attorney General, without a statute, lacks the authority to represent the state in the district court in this case.
Thank you, Mr. Martinez.
Thank you. We ask you to affirm.
Did you all waive the UDJA?
We can't because it's jurisdictional. You can't waive a jurisdictional issue. Let's be very clear about that. This came up on a plea to the jurisdiction. Sovereign immunity is jurisdictional.
Seems unfair, but I agree that appears to be generally
Let's be clear about what Garcia and Harney were about. They were about statutorily and constitutionally created causes of action. They were not about common law action. Let me read a passage from that. Since there's no constitutional or statutory provision which vests the Attorney General the power or makes it his duty for the removal of county officers under statute, the Attorney General cannot assert or exercise such power. That's always been the rule. When the legislature creates a cause of action, the legislature gets to decide who can bring it and who cannot bring it. That's always been the rule. But when we're talking about common law power, the question is, has the legislature repudiated it or not? Because of cases like Taylor and cases like Marino from the Texas Supreme Court, which say we have to have a clear statement to repeal the common law. I'm a little bit interested in what happened to the ARPA funds that have been at issue in this case for several years. We were told they had to be committed by December 31st, 2024. The county says they found some new funds. That doesn't quite answer what happened to the ARPA funds. Day, Land, and Cattle and Brady v. Brooks. Let's talk about those for just a minute. Day, Land, and Cattle says the court need not decide this exact issue here because the legislature passed a statute that did not grant the Attorney General affirmative power to bring a common law trespass to tri-title action, but rather retroactively ratified his act of using a common law power. That's how Brady v. Brooks interprets the Day, Land, and Cattle case. That's where we get the rule, where Brady v. Brooks says, if the legislature had the power to ratify an act, well, it probably also has the authority to give him causes of action affirmatively. That's what Day, Land, and Cattle is about. Hill, of course, is a case from the Austin Court of Appeals, so it doesn't bind this court. But more importantly, Hill is a case that held that the Attorney General can't sue a state agency, his own client. That's, I think, very significant here, because if the only way to reconcile Harris County's argument with Hollins is if the counties are supposed to sue their own clients for ultra-virus acts. It seems they're suggesting that the county attorney should sue Harris County officials rather than the Attorney General's office doing so. Otherwise, no one, or no government entity at the very least, could bring any lawsuit for ultra-virus acts. My friend on the other side brought up a point about the 1869 versus the 1876 Constitution and what the powers of the Attorney General are. And it's true, they repealed a provision that said the AG can superintend district attorneys. We're not attempting to superintend district attorneys here. We're using previously granted common law power. And I'm also afraid that their argument is a little bit inconsistent with the court's recent Webster decision, which explains that the Attorney General's office predates the Constitution of 1876 and was incorporated into the Constitution of 1876 and did not repeal any common law authority. My friend on the other side also brought up breach of contract cases. If the Attorney General's office has no common law authority, counties certainly don't either, unless they're granted by statute. I don't think a county could ever bring a breach of contract case other than the provision that we cited in our brief that says they may bring them for architectural and engineering services contracts. The other point that I would like to make in that similar vein is Harris County has sued the state repeatedly using the common law ultra-virus tool over the past several years. Perhaps the biggest example was Abbott v. Harris County, what became known as the mask mandate case. That was an ultra-virus suit. If the Attorney General has no common law authority, I'm very surprised to learn how Harris County brought that suit in the first place, because it too was a common law ultra-virus suit. And let's see if there's any other points. I think that is probably it. So unless the court has no further questions, we ask that the judgment be reversed and that judgment be rendered for the state.
I do have a question about this notion of a facial challenge when perhaps the program has not been fully developed at this point. How do you respond to, this may be appropriate as an as-applied challenge once, all the details are solidified, but at this juncture, on its face, there's just, too much that we don't know, and some of these problems could be fixed.
Well, I'll begin by noting that in the Uplift Terrace case, the county argued that we had brought the case too late. And I'll also begin by noting that a problem we had in the Uplift Terrace litigation was that the county testified in court what day they intended to make payments, and then decided to make the payments a day earlier when they discovered we were going to seek mandamus relief in the Texas Supreme Court. So as to, did we sue too early, I think that motivated the reasons why we brought that suit when we did.
But still, going to the notion of a facial challenge,
Sure.
That's a high bar to clear. And it's, we would be perhaps doing something for the first time.
I don't think so, Your Honor, because I think the court can hold that as this program exists right now, it violates the gift clauses. Perhaps Harris County will make a new program after that, and we'll have to determine if that new program complies with the gift clauses. But as the program exists right now, after a final judgment has been entered by a court, I think the court can say, as this program exists today, it violates the gift clauses, and I see my time has expired.
Thank you, Mr. Mendelson. Thank you for giving us another difficult case to work on. The marshal will adjourn the court.
All rise. 15 quarters of